Something's weird. Hey guys, hey everybody, welcome to Making Law Simple. For some reason, I can't see. Are we up? Are we live? We are live. Okay, great. I don't know why it was giving me issues, but hey, welcome everybody. My name is David Helm. I'm a licensed practicing attorney in the state of Michigan, practicing also in Oakland County, where the Crumbly case is going on. And with me, if she's done texting, is McKinley. Welcome.
Hey.
McKinley is a Texan attorney, though we don't hold it against her. But she sat in with me on part of the Jennifer Crumley trial, so I thought it'd be fun to have her here today, and you guys will find out why in a little bit. But welcome everybody, Lady Law. Hello, hello. Lady Law apparently has some questions for you and I, McKinley. She put it
Yes.
in Discord.
Oh, okay. That's where it is.
Yeah, it's in Discord.
Okay.
I can't remember. We'll pull it up. There's some evidence questions that she has for us. Apparently, we're her tutors for her class. So,
well, I wasn't great at evidence, so
that's why McKinley's a court-appointed attorney. Everyone, hey Murphs, welcome. Good citizen, good to see you. But yeah, so we had day 2 of the trial. McKinley, did you watch any of the trial today?
I have not. No, I was working.
But you watched Jennifer's trial, so it's essentially the same thing.
Okay.
Yeah. So if you recall, do you recall the crying cop?
I do remember the crying cop I think he was crying because of what took place, right?
Well, and he started to break down when he was testifying about driving up to the scene. So he did the same thing in James's trial, like at the same moment started crying at like the same cue, we'll say.
Sus.
Yeah, so we played that yesterday, like the side by side of where he like broke down, looked identical, same spot in the testimony. You know, he's told this thing 100 times, but yet he continuously broke down at the exact same spot. Crying because the drive was so insane. Yes. Yeah. He's talked about how he had to stop at the intersection. And I don't know what he was talking about, why it was even relevant. But yeah, that's where he started crying. So cross-examination of him took place this morning. And that was really the first time that we got to see a difference in the strategies between James' attorney and Jennifer's attorney. The case in chief, the direct examinations are all identical. They're calling the witnesses in a little bit different order. Like this guy the crying cop was the second state witness, whereas last time he was, I think, witness number 5. So we're going to talk about his cross-examination because I really liked it. And actually, I wanted to play it a little bit so that we could see the difference. And actually, so I've got both of these pulled up. So this is the cross-examination of the crying cop from Jennifer's trial and the cross-examination of the crying cop from earlier today. So we're going to watch those and compare and contrast, because a lot of people don't, I think Ian said it on Laid Back Law earlier today, that when you go to law school, like before you go to law school, you think, oh, well, the law is the law, just follow the law. And it's not. There's so much gray area, right, McKinley?
Right.
So, and the other thing is that a jury trial in particular, is very much a performance piece. And so if you have different characters playing the different roles, it's going to come off differently.
Yeah. I just realized that obviously it's a different defense attorney, because I was like, I don't know why they would do anything different, but I was not thinking. My brain's fried, I think, because obviously last time they lost. I hope that this defense does things differently, but yeah.
She does a lot of things differently.
Okay.
And I wanted to, so we'll go over the cross-examination of witness 3, or the what witness 3 had to say. So witness 3 was Robert F. Cotels Jr. He is a forensic lab technician from Oakland County. I don't remember him testifying in Jennifer's trial, but he might have. It's just weird that I didn't recognize it. But essentially, he was there to testify about bullet casings, a magazine that was recovered, And basically, I kind of saw it coming. He was basically just going to say, yeah, that was the gun that James bought that was used to fire all these bullets and all that stuff. And there was no cross-examination on him because it's really immaterial. Everyone's admitting to this, that the shooting happened and Ethan did the shooting, and the gun that was used is the one that James purchased. The fourth witness was Cammie Beck. She was the gun store owner that we saw in Jennifer Crumley's trial. Her direct examination was identical to Jennifer's, except she identified the defendant sitting there, which she didn't do for Jennifer's trial, obviously, because James is the one who purchased the gun.
Mm-hmm.
On cross-examination, it was very short, by the way. It was like 20 minutes. Most of these crosses are 20 minutes, which they should be. They should be short and targeted, unlike what Shannon Smith did, which was just so round and about kind of thing. But essentially, the cross-examination was limited to, you gave paperwork. The paperwork said X, Y, and Z. Yep, X, Y, and Z is within the bounds of the law. Children are allowed to possess a handgun, under certain circumstances. And you gave them a trigger lock, right? Yep. Okay. And just because you gave him a paperwork that says I gave him a trigger lock doesn't mean that he had to use it or that he promised to use it, just that you gave it to him, right? Or not a trigger lock, a cable lock. And she said, yep. And that was it. That's all you really need to cross-examine that witness on. We had Joe Bryan, Detective Joe Bryan was the fifth witness. He's the one with that interviewed James and Jennifer Crumley.
Okay.
And played the video. If you guys recall the interrogation video of James and Jennifer Crumley, he's the one that that was interviewing them and played that video. The cross-examination on that was really more or less okay. I mean, I didn't think they won any home runs with it, but I also think there was a little bit of a slip up. So, if you recall, James, when he's leaving, if you recall the setting, James and Jennifer are being interviewed in a room together. Cross-examination was that James is anxious but cooperative. He tried to get to the school, but they weren't allowing him, and he was trying to get a hold of his son on the phone. He said that his son was a perfect kid. He had some great issues, but other than that, he was a fine kid. No problems with the law, no real behavioral issues. James said the gun was hidden in a case and that the bullets were hidden in a different location under some blue jeans. And James said that he wanted to hire an attorney for his son. The bullets were
hidden where?
Under some blue jeans. The bullets were hired under some blue jeans, or hidden under some blue jeans. And the gun itself was hidden in a case. It was like put away in a case somewhere.
Okay. Sorry.
Oh no, wait.
I messed you up. I'm sorry. I won't do that again.
Oh, it's uncivil in the chat? Oh, hey.
No, I did not see that.
Hey, Kurt, you've been watching this. You want a link? I'll send you a link. But sorry, I haven't been watching the chat. So that was the big difference with the cross-examination, is that was like to the point. Where the slip up is that she specifically asked about James saying, I love you, I love you, I love you, I love you. I think he said like 5 times or so to Ethan as he's exiting the room, which then allowed the prosecutor to cross-examine about that and ask the officer, what was Ethan saying when James kept saying, I love you, very loudly. And Ethan apparently was confessing, saying, I did it. And so the implication is that James wasn't necessarily saying, I love you, but was trying
to shut up.
To shut the fuck up. Yeah. Which isn't necessarily a bad thing, but it's not I love you, right?
You just lost your monetization.
Yeah, I'm okay with that. All right. Now that I'm done talking, I'm going to send Kurt a link if he's at all available or interested. Let's see here. Where is Kurt? Here he is. Because I think he's been streaming it. So that's a couple of the big differences that I noticed is that they're short, sweet, and to the point. Like I said, this cross-examination was maybe 20 minutes. And in fact, they ran out of witnesses today because it was going a lot faster than the prosecutor anticipated.
Oh, wow.
The last witness for the day was the assistant principal at Oxford. Her direct was more or less the same. She added a little bit of heroism to her direct, in that it was specifically referenced that when everyone was supposed to be leaving the school, she ran into the school. When everyone was running away from the sounds of the bullets, she ran towards the sounds of the bullets. When
She didn't
the
think she
retired
sounded, like, good enough the last time, I guess?
I guess, I don't know. It was very different. It was very
That's weird.
heroic sounding, her testimony today. And of
That's really
course, there
weird.
was no cross-examination.
That's so odd.
Yeah. So that was that was it. So we had cross-examination on witness 2, and we made it through the 6th witness, and it went very fast. And in fact, they ended early. They ended at like 2:30, which I wasn't anticipating. I wasn't even in front of the computer, and so I had to remotely just like end the stream.
That's crazy.
Yeah, so they ran out of witnesses.
Yeah.
So this case is going to be wrapped up probably a lot quicker. The Jennifer's was 9 days. This one is probably going to be, let's see, it was 9 days for direct, right? No, it was 7 days for direct. Then we have 1 day of the defense case in chief, and then we had like the closing arguments, cross-examination, closing arguments. So I think that was 9 days. So they did theirs in 7 days. So the state presented their case in 7 days. It's probably going to be less. It's probably going to wrap up Wednesday, I would say, for the state's case in chief, and then we'll see how the defense is going to present their case, if at all. You know, they don't really have to present a case, but let's see. People be idolizing the Crumbly. It's so strange. I'm not idolizing them. I'm just saying that from my standpoint, it's not enough to find them guilty of a criminal charge. And the way I've broken it down from a legal standpoint, and McKinley, jump in if you disagree with me, but generally speaking, throughout history, you're not responsible for the intentional wrongful acts of another. The exception generally being if you co-conspire together, right? If McKinley and I conspire to rob a bank, then we're both equally responsible because we planned it together. It was an intentional act by both of us, even if I was just the one that scoped out the bank and she was the one that actually did it. We had a partnership. We both played our roles, that sort of thing. Outside of that, you really don't have liability for the intentional wrongful acts of another. Now, there's been some exceptions built in when it's not intentional. So when it's negligent. And the case that the state is relying on, primarily in Michigan, the one case that they hang their hat on that gives them the window that the Court of Appeals says, okay, maybe we'll see how the facts bear out, is a case involving a father who had a loaded gun. I don't know if he was a father. He was in charge of 2 children. They were like 4 and 6 or something. And there was a loaded gun in a closet, and the terms in the case was lock them in this room where the closet was that had the loaded gun, and the one child got the gun and shot the other
Oh,
accidentally. It wasn't on purpose, and he was charged with involuntary manslaughter, and that was upheld, saying that he intentionally created this dangerous situation by having an unlocked loaded firearm with very young children around, locking them in the room and not really checking up on them. And so that's the case that's been used to justify this charge. But I don't think it applies when there's an intention or an intentional wrongful act. So that's why I'm not loving on them. I could care less if they're good parents. Are they good parents? Probably not. Are any of us good parents? Probably not. But we are parents, and to be held criminally responsible for the intentional wrongful acts of your child is a dangerous situation to start creating. So that's my position. And I've seen you throughout the chat during the day, and you are absolutely welcome to offer your comments. And I'm not like picking on you just because it was an interesting comment.
Yeah.
So, but welcome.
I'm surprised that I was like, wait, what's happening here? I was starting to think maybe I was like streaming and behind, lagging somehow because they came up with the answer before you said it. And I was
What's
like,
that?
wait. Like, so if Ethan accidentally killed them, they could be charged for providing the gun. But since he intentionally did it, they can't be charged.
No, that's not.
No,
that's not the situation. It is. So the state court of appeals. By the way, so if you don't know the background on this, they were charged, and then there was a preliminary examination, which the court has to be satisfied. The lower court, the district court, has to be satisfied that there's probable cause to bind them over. That was done. Then they filed a motion to quash that, say that there's not, this act that you're alleging them of is not in fact a crime. And the court said, no, it is under this very narrow interpretation. So then they went to the Court of Appeals, and the Court of Appeals said no and kicked it back down to the trial court. The defendants then filed to the Michigan Supreme Court, and the Michigan Supreme Court said, Court of Appeals, you should have done an actual hearing on this, not just kicked it, because this is a new, interesting, novel sort of approach here. We want some pre-assessment before we take it on. Okay. So then the Court of Appeals had a hearing, I want to say last February, so like a year ago. Okay. Court of Appeals had a hearing, and very poignant questions on both sides. They're both, all the attorneys were hammered on this issue. And the Court of Appeals came back and said, well, if you can show that they allowed their son to have unfettered access to this firearm, then it falls into this category of where they could have created this situation. Now, they still have to show that they knew he was a danger, right? Because it can't just be unfettered access. That's not the line. But if you can show that he knew he was a danger and they allowed unfettered access, then we'll allow this case to go forward. There's been some evidentiary issues that I'm really concerned with.
The danger part comes in because of the intentional, right? Because like in the other case, it was negligence.
Yeah.
Basically.
Well, basically, in the other case, the court found like he knew he was creating a dangerous situation by locking these two very young children in a room, not checking on them for a couple of hours.
Oh, he locked the kids in the room.
Yeah, I thought he locked kids in a room.
Guns in a room. Oh, wow.
No. He locked kids in a room, and it was like a bedroom, and in that bedroom was a closet.
Oh,
in that
crazy.
Unlocked closet was a loaded shotgun.
Oh, that's crazy.
It was a sawed-off shotgun, so there was like added firearm charges.
Oh, yeah. Too. Okay, that makes sense.
Yeah. So the court was saying in that case, well, he grossly negligently created the situation because he knew there was a high risk. Kids of that age just running around unsupervised in a room for several hours with a loaded gun could cause a problem like this. Right. So the Court of Appeals was saying, if you can demonstrate that it was that kind of reckless conduct, unfettered access to a gun, no supervision, you knew that because of his mental state, there was something going on, then maybe this could be a case. So we're going to kick it back down and let it go to trial.
Okay.
So that's how we got here.
Okay.
But it's a very narrow issue, which is the problem is that like it was applied first to that situation, right? Where you have a guy who locks a kid in, he's probably guilty of child neglect in the first place, right?
Right.
And then it leads to an accidental shooting and they charge him. And they're like, well, and the court even said in that case, for this time only these circumstances.
You can't do that.
Well, but yeah, you can't, because now we're going beyond those circumstances, right? And we're using the same approach. So that's the scary thing about using James and Jennifer Crumbly or charging them, is that we can say for this time only. And in fact, the prosecutor has said, we're not saying anytime a child does something wrong that the parents are going to be responsible. It's for this time only, which was said in that case.
Right.
So, so that's the scary problem with this.
Right.
And
here they have the intervening act, right?
Right. And here they have an intentional wrongful act, which just for comparison purposes, say you have an employee and you allow him to drive a company vehicle, and that employee negligently gets into an accident. Well, the company can be responsible. But say that employee intentionally mows down 5 people at a parade. The company's not responsible in that situation. At all, like civilly or whatever, because it's an intentional wrongful act. It was outside the scope of the employment. The employment was not to run people down. The employment was to drive the van to wherever for the purposes of the business. So that intentional wrongful act is a bar against any claim from the employer. And it's the same way with any sort of agency or any sort of anything. And it's always applied to criminal things as well. In fact, there's a ton of cases that I broke down that's from the criminal context that specifically says the intentional wrongful acts of another being a direct intervening cause bars you from criminally prosecuting this person. There's ones involving car chases and there's all kinds of cases like that. But at the end of the day, the intentional wrongful act has always been a bar, and we're setting aside that for this circumstance is scary. So I'm not championing the Crumblies. They can be shit parents. Charge them with child neglect. Charge them with child abuse. Charge them with contributing to the delinquency of a minor. You can charge them with those things, which I think are more. I would have no problem if they charged them with those things. It's the manslaughter on a gross negligence standard when there's the intentional wrongful act.
Yeah, that's a little crazy.
Sorry to go on a rant, but those are my feelings. I want to feel my feelings. All right. I'm way behind in chat.
My hair
let's see here. Yeah. Sorry, I'm just picking up on your chats because I was looking at your responses. Dave, to take that chat down. Okay.
Wait, what? What? Take what chat down?
Oh no, she was just saying it because I left the chat up the whole time I was
talking. Oh, okay. I do that every time.
You miss my rants. I get on a roll. With my rants. McKinley.
Yeah. What's up?
Would you like to watch some comparing and contrasting of these cross examinations?
I would.
So the reason why, like, I can't stream and comment live, but I'm really interested in this case. Really, the only thing that's different is the cross examination. There's different defense counsels, and style is what I'm really looking at. So this is my thought. I know you've seen you've seen Jennifer's trial, but I want to play that first. I think I want to set this baseline for where we were coming from with Shannon Smith, and so I'm gonna put it at.
Y'all try not to hate too much about Shannon Smith in the chat. Y'all know how that triggers me.
I'm gonna play it at 1.25.
Okay.
If it's too fast or something, I will we'll slow it down. But I'm gonna play this. I'm not gonna play all of it because so here's the other thing too I wanted to point out. So cross-examination, and this is of the crying cop. So cross-examination in Jennifer's trial went for over an hour. Then there was a break. Then there was another hour and 20 minutes. So we'll say 2 hours and 30 minutes, 2.5 hours for this cross-examination. I'm not going to play all that. Jennifer's cross-examination, James's cross-examination today went for 45 minutes.
That's way better.
And I feel like I feel like today's cross-examination for James was way better. So I just want to, this is an educational thing here. So let's take a look at this. Let me know if you guys can hear it. I'm doing this dual stream thing. So check it out. You guys hear it okay? Should I turn it up?
I can hear it, but I don't know if they can.
I'll boost it.
Good afternoon.
Good afternoon.
I want to go back to, I want to just start, you've been obviously involved in this case since the 30th of November, 2021, correct?
Correct.
And since that time, you have collected and looked at an abundance of evidence related to the Crumbleys, the shooter, the shooting, everything, correct?
Correct.
And when you were testifying earlier, you testified that at a previous hearing, you had testified about the parents when they first went into Oxford High School, correct?
Correct.
And on that date, you had reviewed many, many materials prior to coming to court.
Correct.
And that hearing was a preliminary examination, which is a hearing that's before a trial, correct?
Correct.
And at that hearing, you did the best job you could in terms of explaining, answering questions.
Correct.
You were truthful on that day.
Absolutely.
As you're being today.
Yes.
And we can agree that you made a mistake about Mr. and Mrs. Crumbly arriving in the vehicle together at the school.
Because of the video, how it jumped, yes.
Okay, an honest mistake.
Correct.
And it's fair to say that when you didn't have more information, you made an assumption that they had been in the same vehicle together, correct?
Correct. I didn't know how many cars they had at the time.
You see them walk into the school together, but you couldn't see before that.
Correct.
And that's why you testified. Honestly, you thought they had arrived together, but it was incorrect.
Correct.
And so you would agree with me that the more information you have about any topic and the less guessing, the more accurate the information will be that you give on this witness stand, correct?
I wasn't guessing before. I didn't know how many cars they had. I just saw them appear in front of the car.
Right. So when you testified and said
I will say she's apologized, but very appropriately. Like, it's not like this. It's not like frantic apologies and stuff like that. I mean, everyone apologized. They're like, oh, sorry, made a mistake. Don't count my math. You know, that sort of thing. It's very different. You'll see the styles.
they arrived in the same car, that was incorrect.
Correct.
And I'm saying that had you had more information about seeing the vehicles pull up or seeing each one get out of separate cars, your testimony would have been different, correct?
It would have been included in the video, correct?
And so my point is, you do the best job you can with the information you have.
Yes, ma'am.
But you're certainly not someone who can go back in time and see and know every detail of every single thing that's happened, correct?
Not every single thing. You could put together a good timeline with all the information that you gather, yes.
And it's fair to say for this jury, you have put together as detailed of a timeline as you can about all of the events before November 30th through 11/30th and beyond 11/30th, correct?
That's correct.
And when you are doing that, you are taking data from cell phones and other investigators,
She has not.
from surveillance,
Okay.
from all these different materials that are a part of the investigation in this case.
Correct.
And it's possible that at times when you answer a question, you may not be accurate, but you're not sitting here intentionally trying to lie, correct?
It's absolutely correct.
Okay. I'm going to go back through the investigation that you did. It's fair to say, and I think you testified, you started obviously on November 30th of 2021, correct?
When the investigation started?
Yes.
Yes.
Okay. And can you give the jury an idea of how much time it takes to get certain evidence or kind of what it looks like going forward from 11/30 when you receive various pieces of information? So on 11/30th, let's talk about what you saw that day. You obviously saw the surveillance camera from the school, correct?
See, so this is part of the thing I'm talking about. Like, she asks a question and then she rephrases the question without any reason to do so. I mean, it was a poorly worded question, granted that, but if the witness is going to answer it, let them answer it. Right, McKinley?
Yeah, no, I don't like her cross-examination style at all.
No, I am not a fan. So
we'll
listen. We'll keep listening.
It looks like going forward from 11/30 when you receive various pieces of information. So on 11/30th, let's talk about what you saw that day. You obviously saw the surveillance camera from the school, correct?
Yes, correct.
Okay, on that day, did you have the surveillance camera from Jennifer's office?
That came afterwards.
Okay, that came down the road.
Yes.
At that time, did you have the text messages between Jennifer Crumbly and James Crumbly?
That came out. No, that would have been afterwards.
Okay, when did that come?
It would have been within a week, 2 weeks. of that. We would have had to, like I explained, the process of getting the data from a phone. Depending on how much data there is, it could take a while, and then to sift through all of it. So it could be anywhere from a couple of days to a couple of weeks to get everything that you're looking for.
And in terms of the investigation, there were materials you had on the 30th, obviously.
Correct.
There were materials you received in the days following the 30th, correct?
Correct.
And there were some materials that law enforcement didn't have for weeks and months that became a part of this investigation. Is that a fair statement?
That's correct.
And as more and more information
the only thing I know is that they shared a firm together. They were partners in a firm. And for whatever reason, James and Jennifer went to them. I don't know if they were referred or whatever. And they hired the two attorneys from the same firm, which is okay to do to some extent. They screened each other and things like that. There's a whole bunch of ethical things that you have to do. I don't know who ended up picking who and why one represented the other. It was just, I have no idea, honestly. But once it became an issue, meaning that their interest might be adverse to each other, they split their firms and they'll no longer work together. And I don't know how that went, other than I know Shannon is apparently a one-person show now, like I am. She doesn't have any support staff and no other attorneys at her office, from what I hear. So
she must have gotten paid a lot for that.
I would imagine so. If she took nothing and left the firm, and
that would be insanity.
Right? Yeah, you get bought out at that point because usually you take something. So yes, this is Cross of the Crying Cop. This is from Jennifer's trial. We're doing a comparison, mainly just in the style. Again, the case in chief that the state's putting on is almost identical, almost. But it's we're just really looking at the style here, because my point is that you can have a great attorney and bad facts and lose the case. You can have great facts and have a bad attorney and lose the case. So that's what I'm just trying to establish here.
Became available, you would turn it over to the prosecutor's office.
Welcome.
Correct.
And then you would assume that they would turn the evidence over to the defense for it to be used in court by all parties and the judge.
Yeah, I do my job. I don't know what they're, they have to give that up. Yes, I understand that.
Okay, so at the time on the 30th, it's fair to say all of the evidence that you have in this investigation, I'm sorry, not on the 30th. The 30th was the day of the shooting, and Mrs. Crumbly was arrested overnight between December 3rd and December 4th, correct?
Correct.
And it would be fair to say that between November 30th and December 3rd, your office and team and all law enforcement were working as hard as they could to collect information and collect evidence, correct?
Correct.
While you were working as fast as you could, there were a number of materials that you did not see until after Jennifer Crumbly was arrested.
Well, just because of the sheer volume of information that we were pulling together at the time, yeah, I mean, it took a while to go through it.
And when you're looking at all of the information about Jennifer Crumbly in this investigation, much of what you're doing is looking back in time in hindsight.
In hindsight, we're trying to put a story together, a series of events or a digital footprint of what had happened. We're trying to put that together.
And as you're trying to put that together, you're doing the best you can to make the timeline and the evidence make sense, correct?
Correct.
But in terms of what happened in the months before the shooting, the day of the shooting, and the days after the shooting, you obviously were not with the Crumblys 24/7, correct?
No, I was not. I didn't know them before this.
And it's impossible to have, there isn't any way to have a videotape, for example, of all those months, that shooting day and the days following, correct?
Correct.
So you take bits of information and try to put it together the best you can to make sense of it.
Are you referring to this investigation or throughout life?
Well, both. I mean, I guess we do that in both, right?
I guess if in my life, if my son had hallucinations, I would have taken serious pause with that.
All right, let's stop for one.
She's like, all right, let's stop. Elephant, yes or no? She hasn't. I'm sorry. She needs to be sentenced first. She's going to be sentenced in April. So after her sentencing, then her right to appeal will kick in. Although I have to imagine that they're sort of like prepping all that stuff to some extent. It's not going to be Shannon doing the appeal though. So ideally she's probably not retaining somebody, but they're probably like gathering stuff together and making a file together for the attorney that's going to be handling the appeal.
Look at John Gary's comment. It's kind of funny.
John Gary. Shannon has an annoying, I'm making a really important point voice. Yeah, she does, doesn't
when
she?
she's not making one. It's like it's that mom thing.
It is. I feel like it's almost it's when an actor doesn't know how to look like they're not acting. Voice. Does that make sense?
Yeah. Yeah.
Right? So if you tell somebody to like act out a scene, like truly try to act it out, and they don't know how to look like they're not acting, that's the voice that's created, the one that Shannon's doing right now.
A lot of I don't know. I think it might be a lot of up talk, right?
Is it up talk?
I don't know if that's the right word for it. There's something.
No, I know what you're like. And then we went to the movies. That's what I think of as up talk. I don't see it as up talk. I see it more. Well, maybe it is a little bit. It's a little something.
There's something. There's something about it.
Something there. Yeah.
Upspeak is what they're saying.
Can this witness update his answer about them arriving in the same car in the James trial? He did, I believe, because I think that's actually pointed out. So he did. The thing that I was really pointing out with this particular witness yesterday was that his testimony was virtually identical, which is fine. You want the story to be the same, right? But he started crying at the exact same time. And that to me is odd because, he's told this story 100 times. He's already testified in front of the court, in front of the media about this already. You're like, okay, he's getting emotional because he's talking about it fully and completely for the first time. He's in front of a bunch of people doing it, whatever. But to break down at the exact same time again seemed a little
staged.
A little bit. It did. But and the other thing is that the jury, presumably the jury that's sitting there right now, didn't watch Jennifer's trial, so they don't know that.
Right. Yeah.
Right?
So it's fine. The only people that know are the people out here that know now, hey, he's acting.
Malcolm says he thinks it's up dog.
Up dog.
Damn it. She didn't fall for it.
What?
You're supposed to say, what's up, dog?
Oh, what's up, dog?
Not much. What's up with you?
Oh, and I even saw that in the chat. Y'all, I am so
oh my God.
I'm so tired today. I don't know what is wrong with me. I did too much. Did too much today.
He's not.
I'll try to get more you don't think he's acting? I think it's like real sus that he does it at the same exact times. To be fair, I thought he was kind of acting last time. And then now you tell me he did it again. So, I mean, I'm biased. I shouldn't even comment.
You, the lawyer who defended the cop of the Florida school shooting, I want to talk like him in court. I didn't watch that trial.
He was amazing.
I like viewed it ancillarily from, I didn't really watch it a whole lot. I was streaming something else, I think, when that was going. Oh, I was doing Letitia Stout. And then while we were, I think, waiting for a verdict on that case, the verdict came in on that case. So we streamed the verdict, but I didn't watch the trial at all because I was streaming Letitia.
Oh, that's crazy because I streamed Letitia some too. How was I doing? I mean, I was streaming Letitia to myself, like to practice streaming, but so I must have just been watching it on another device.
I was streaming something. I don't remember what. Oh, you know what? No, I was streaming. Ronald River, the Border Patrol murder case. That's what it was. That's what I was streaming at the time.
Okay.
It wasn't.
I think at some point I gave up streaming that.
That was a horrible case. I gave up streaming it and passed it to Baker. He thanks me for it every day. All right, we're going to watch a little bit more of this. Then we're going to switch over to the cross-examination from today.
1 second.
Just got to take a second.
When you say hallucinations, you're saying that you would take serious pause, but in reality, you did not know the shooter before this shooting, correct?
No, I did not.
You do not have awareness if he was really having hallucinations, correct?
I would have taken some time to look into it.
You're aware that there's this text thread, and we're going to get into it later, where he's telling his parents he's seeing things, correct?
Correct.
But you weren't a part of any of the conversations or a part of that household in those days around that text message conversation, correct?
No, I was not.
You're not, okay, you're not aware of what Jennifer and James and their son had been talking about in person before and after those text messages.
Well, from the text message, I know the son on a couple of occasions asked or spoke with his friend about seeing a doctor or wanted to go see his doctor. Tell his parents tell his parents that he wanted to go see a doctor.
And
do you have it sped up?
Text between
1.25.
the shooter and his friend. You have
Because it goes on for 2.5 hours.
You know what's crazy? You can't even tell that she's speaking any faster. Like she just sounds normal.
Well, let's play it at normal speed.
It's only when the dude starts talking that you can tell.
Yeah. All right, normal speed.
no evidence that Mrs. Trump has ever seen those texts, correct?
That she has read them? No, I do not.
You have, so there's texts that the shooter sent to his
So much
friend,
worse. So
and
much
you
worse.
have no way to know whether Jennifer Crumbly ever saw those text messages, correct?
Other than his own words say, I'm going to tell my parents tomorrow that I want to go see a doctor.
That telling his friend, I want to go see a doctor and I'm going to tell my parents tomorrow, you don't know if he really wanted to go see a doctor or was going to tell his parents, correct?
I believe he
I understand that's counsel's argument, but it's improper questions. You already answered the question.
Okay, you don't know whether Mrs. Crumbly saw the text. between
Her
herself
voice
and his friend.
sounds
No,
to me
I
like
did
a
not,
panic. Yeah, she's got a panic attack voice. That's a good way to put it. Is that it? Is it? She's got panic attack. Is it a condescending voice? No, something about it.
And I'm also making the point, Your Honor, and the question is,
He is
you also
condescending for sure.
don't know if it's true that he really planned to tell his parents anything. He has a text to a friend saying that, but you don't know whether that's true or not, correct?
Other than him saying on a couple occasions, no, I don't.
Okay, and when you say a couple of occasions, there's text messages on certain days that
Yeah,
we've
wait,
talked,
Rabbit.
that you testified about, but there's many other days, we can agree, that you have not testified about, correct?
In reference to what?
In reference to what he said to his friend, or in reference to what he said to the Crumbleys.
I mean, did he have are you asking, did he have conversations with them? I don't understand the question. I'm sorry.
I'm sorry, my question is, you've given us bits of information about certain days, about March 9th, about a date in April, about a date in November, correct?
Correct.
Okay, there's a lot of other dates that you did not give us information about what exactly was texted to and from Ethan Crumbly and Mrs. Crumbly, correct?
Correct. There wasn't much texting between them.
Okay, you also, there's certain messages that you
Nick,
testified
get your ass
about
up here.
between the shooter and his friend.
Correct.
There's also a lot of other text messages between them that you have not talked about.
Well, because the stuff that was talked about was not allowed to be talked about. You talked about,
Your Honor,
Yeah.
This-
Well, I think it's important, Judge.
Yeah.
Counsel can't ask questions about evidence that she sought to exclude.
Okay.
telling
Yeah, but
this
speaking
that
objections are
evidence
next.
that was irrelevant is very unfair, and that is improper.
Okay, well, there's.
Unfair. Unfair is not an objection.
No one's hiding any
No,
evidence
it's
from you.
unfair.
Okay, so I don't want any implication that our witness is hiding what evidence from someone. So,
Thank you, Judge.
Okay, so are we following her cross-examination? Do we know what points she's trying to make? Are we following it at all? Anyone? Hey, Wendy.
Oh, I'm talking to Broken Baker about him being a grouchy streamer.
We're
Sorry.
so happy to see MLS. Thank you, Wendy H.
I know,
I'm so
right?
happy to see you in the chat. And Jamie, look at Jamie's in the chat. Baker must be done
Where?
streaming.
Hey. Huh?
Um,
He's at a bar.
I know, I heard. Is that like a high school reunion or something?
Oh, okay.
All right. But do do we have any sense of the point she's trying to make? Are we following along? Are we just getting confused? Is it turning into white noise?
It's turning into white noise.
Right? Exactly. Okay. I think that's enough. And I think my point has been made for at least her style. Now, this is James' attorney today, same witness,
Okay.
starting cross-examination. All right, I'm going to boost the volume real quick. So do that.
Thank you for being prompt. I want you to know that none of us slept in and we weren't sitting around drinking coffee, so we knew you were here, and we're conscious of that. And so we're going to continue.
Wait, Gabe?
Yeah.
Why does the guy have the headphones on?
He's got a hearing problem, and so the headphones are actually linked with the Zoom. If you guys listen to my stream, I do it through Zoom, and that's the court's in courtroom audio, and he's listening to all of that, so he can hear everything.
Okay.
Yeah.
I feel like I had one more question. Oh, am I loud, chat?
No, not
Okay.
loud to me.
Thank you.
She disappears. All right.
Yes, ma'am.
All right, you can be seated, and please then state your name for the record and spell your first and last name, please.
Edward Wagrawski, EDWARD, last name WAGROWSKI.
Listen.
Thank you, Your Honor. Good morning, how are you?
Good, how you doing, ma'am?
I'm well, thank you. I may or may not use the screen, so I might bring up a paper exhibit to you if I need to.
Yeah, this one doesn't appear to
Yeah,
be,
let
it's
this happen in a
something's going on there.
second. The issue I mentioned.
I will say this is not the same as Shannon Smith not being able to use technology. There was actually a technical issue with the monitor that the court had to fix at lunch. So
Does she have sunglasses on her head?
Yep.
Sunglasses?
She's cool. No, I think they're eyeglasses, actually.
Okay. They're Gucci, though.
Are they?
Yeah.
Oh, they are Gucci. Because she's
Gucci.
high-powered. She can afford those things, unlike me.
She Gucci,
got,
Gucci.
I've got busted gas station glasses. That's what I have.
Mm-hmm. Same.
You think it's funny that the headphones have masks on? Yeah, I know.
Gotta be sanitary.
All right.
A minute ago, this screen is flashing.
You know what, Your Honor, why don't you turn it off? I have the exhibits printed out, so if I need Mr. Wagrawski to look at it, I can walk it up to him.
You can let RIT.
Thank you, Your Honor. Mr. Wagrawski, in November of 2021, you were employed by the Oakland County Sheriff's Office,
Yes, that's correct.
and you were employed in their computer crimes division.
Correct.
You testified yesterday that the main objective of your position was to obtain evidence for criminal prosecutions.
Kurt, welcome.
Up.
How we doing?
Oh, hey.
Good.
I didn't even notice that that you came on. Hi.
I brought him on. I figured I'd stop and just acknowledge. Hey, you watched today's trial?
I haven't so much. No, I was running an errand this morning, and then by the time I got back, they basically were ended for the day.
Yeah, I know they ended early because this attorney, kind of the purpose of what I'm doing here today is sort of comparing and contrasting Jennifer's attorney, cross-examining the same witness as James' attorney here today. It's fractions of the time. It's pointed. It's exactly what you want to see from a cross-examination. And in fact, it's done so well and so competently that the prosecutor ran out of witnesses today. so they ended at like 2:15 or something stupid like that.
Yeah.
So anyway, so we were just starting. So this is the cross-examination. If you remember the police officer that was crying on the stand in Jennifer's trial, when he was talking about how he had, when he was arriving at the school and everything, and the little girls in their skimpy outfits and stuff, and he was crying about all that. So I played a little bit of his direct examination from yesterday, and his direct examination from Jennifer's trial. And, most of the direct examination is the same because it's the same essential facts, but he starts crying at the exact same time. With the same enunciation at the same word, and it's really weird. He starts crying at the same time. So that got me thinking, well, I should compare and contrast these cross examinations, because I feel this attorney here, James' attorney, is much has a better presence in the courtroom.
I tend to think so. I liked her opening a lot better, but it did make me concerned for the overall case, because I found her opening, and let me know if you disagree, but I found it a little vague and amorphous. It didn't really. She said things like, "Well, they're gonna point to these things. We'll point to these things. They're gonna do this. We're gonna point to this." But it didn't really feel like she had evidence of her own really to offer. She didn't say, like, "You're going to hear from this witness who's going to testify about how this is not predictable," or things like that. So it felt a little bit. It felt a little bit like they have the burden of proof and make them prove it. It didn't really feel from her opening that she had a case of her own really to present.
Well, I think the biggest thing that she was trying to do in her opening, which I hope the jury took note of, is that she didn't want the case to be about the shooting, and didn't want the emotions to get tied up in this and render a verdict on emotions. And specifically, she said that this case is not about what happened in the school, but what happened outside of the school. So you're going to see videos of the shooting, and you're going to see or hear testimony from people that were shot and were in the school. But this case is not about that. And I think that might have been her primary goal of the opening, is to get the jury to focus away from what happened inside of the school and to focus on, everything else. That's really kind of the issue, and not make it emotional, because this is a tragic event we're going to convict.
If that was her goal, I don't really know that it accomplished it, because she knew, and it has turned out that as you would expect, because the prosecution's running the same playbook, that they're front loading the emotion to spike the emotion. So don't pay attention to the emotion you're about to be spiked through. I don't really think that message was successful. If that was the goal.
I did notice that on some of the cross-examination she did. Let me pull up my notes here real quick. I think she tried to minimize the cross-examination to some extent. So we had there's
no particular need for cross of these witnesses.
Not all of them. No, not all of them. The biggest one was, well, there's no need for a cross-examination of the teacher. That was the first witness here. The second witness was this one. And then there was another witness that was talking about the school stuff. Like basically anything that has to do with the school, she was just like not crossing, or would ask like one or two questions and move on. I think one of her cross-examinations took like 20 minutes, if that, maybe 15.
Mm-hmm.
I wasn't really timing it all. I thought she had a better cross of the gun store employee, which was really to the point. Again, that was fairly short.
So maybe you're right.
That was today. And then the assistant principal, no cross on that. So I think she's just, sometimes the less time you spend on something, you're emphasizing the fact that this isn't important, I guess.
I have no problem on the emotional stuff, because there's really nothing to be gained. What can you possibly gain? You just stay on the emotional topic of, I was involved in the shooting. What possible questions can you answer? That's going to help. Plus, the state gets rebuttal direct. So what are you trying to accomplish? There's nothing to be gained. So
but this cross-examination of this detective or whatever he was, he's the one that essentially pulled all the videos and the cell phone data. And if you recall, he's the one that
I listened to him the first time. I remember.
Okay.
I'm sorry, main objective
of your position was to obtain evidence against someone accused of a crime.
On that day of November 30th?
No. As your role with the Computer Crimes Division.
We were looking for evidence if a crime was committed, yes.
And you reviewed electronics?
Correct.
Social media accounts?
That's correct.
Other similar sources of electronic data?
Correct.
And the goal was to obtain evidence against a person accused of a crime. Is that fair?
Attempting to see if a crime was committed, correct.
Your goal was not to obtain any exculpatory information that would clear someone from a crime. You were looking to see if somebody committed a crime. Is that correct?
That's not true. No, if we find evidence like that, obviously it would be relevant to look further into that, yes.
And you did the same thing in this case. You reviewed the electronics, the social media accounts, and other sources of electronic data.
Correct.
You reviewed cell phones that.
See, one of my points is like, so when he comes back and says no, if there was exculpatory evidence, we would look deeper into that. Which I feel like Shannon Smith would have spent the next 20 minutes trying to get him to answer no.
It was annoying to me, though, that she continued on with her script. It's like, well, that's not what he said, though.
Yeah, I know. That wasn't the question asked, but she knows she's not going to get the answer out of him that she wants. So just move on.
Yeah.
Was my thought. And I think, like just watching Shannon for 9 days, she would have dove into that for 20 minutes. I don't know, Kurt, what are your thoughts? Do you think Shannon would have jumped on that?
I mean, I could have, I don't know, because I don't know that it's necessarily inherently obvious what's exculpatory or not when you're trying to find the initial investigation, when you're trying to figure out like who done it. Presumably you want to find all the information, because evidence that tends to suggest someone didn't do it is perhaps cause to look for someone else. So it's a weird question. It's like we're trying to look for any information that might help us figure out if a crime's been committed and by who. You don't look for exculpatory information. It's like, well, in a sense, we kind of do, because we're trying to look for any information that helps us figure out who the bad guy is. So
but they don't, though. Yeah, that's
but I get the point she's making in that once you identify someone as your suspect, you tend to look for evidence that will implicate that suspect,
confirmation,
rather than evidence that will.
Well, if that was the question, then it was poorly asked towards that purpose, in my view.
You know what I think? I think that you're right, though, Dave, in that she got her point across, hopefully, and then she moved on because he was never going to agree with her, right? So she just moved on to the next question after she got what she wanted to say out there, which we knew what she was saying.
She does that a couple of times with a couple of witnesses. I can't remember if it's this one or not, where she really doesn't get the answer, and because there's an objection or for whatever reason, but the question is out there, right? And it's like, all right, you kind of made your point and you moved on.
Mm-hmm.
The question is also slightly flawed in its inception, because it's essentially the ultimate question, because you don't want to ask a witness, particularly a hostile witness, the ultimate question. You don't want to ask them like, you did this, you did this, you did this, therefore this is true, because it gives them the opportunity to fight you. So you want to ask the questions that lead to the conclusion, if you can. Instead of asking, well, you don't look for exculpatory evidence. You want to ask them questions that would presumably lead to that conclusion, rather than have them fight you. But I do appreciate her moving on. It's the right call.
Yeah. Well, that was kind of my point in stopping it, is that the right call was to move on. Whereas I didn't think Shannon was capable of doing that a lot of times.
She was.
On to James Crumbly.
That's correct.
You identified that there were 3 cell phones, if I recall correctly, from the prosecution's PowerPoint.
Correct.
2 of them had the same phone number.
That is correct.
So there were 2 Android phones that had the same phone number.
Correct.
And then there was a 3rd phone, which you called a burner phone. Or I'm sorry, excuse me. The prosecution called it a burner phone and you agreed.
Correct.
That's a phone that you buy at, I think you said Walmart or Meijer or a store like that, a track phone, something along those lines.
Correct, yes. Something that's you can just buy.
This is at normal speed too, by the way.
And if you know, James Crumbly and his wife were told to get a second phone because they gave their phones to the police that day.
I was not told that, no.
You're not aware if that happened or
I'm
not?
not aware of that happening, no.
While you were in the process of obtaining surveillance footage, you were not aware of the identity of the shooter at Oxford High School?
Not immediately.
And at that point, you don't recall anyone at that point, meaning while you were reviewing the footage at the school, you don't recall anyone saying, oh, it's so-and-so, until at some point later?
Later, within, it was probably, I'd say 25, maybe 30 minutes. We were looking at the video and then someone said his name.
Okay. So, and I'm not going to ask you to say his name. The judge has made orders regarding that, but it wasn't initially anyone at the school was like, we know who it was this person. Is that accurate?
I believe the person was identified by the deputies that took him into custody, but that wasn't related to us. We were I was in the security room at whatever time it was, and we were just looking for the person that came out with the black zipped up hoodie on.
Okay. For Exhibit 61, and if you need me to pull the exhibit for you, I will. Yes. I'll tell you what it is. Exhibit 61 is a Facebook conversation between James Crumbly and his wife. Did you want to look at it?
Yes, please.
Okay. May I approach, Your Honor?
Sure.
Do you recall reviewing that yesterday?
Yes, I do.
Okay. And that exchange is about James Crumbley's son.
Correct.
You don't know the context of the messages, is that fair?
In what, I mean, the context of what was being said, the words speak for them, I don't understand.
Right, the words speak for themselves, right? You know what's on the page.
Correct.
You don't know anything beyond what's on that page.
That's correct.
You talked about texts. May I approach again, Your Honor, to get the exhibit?
Sure.
Thank you. Thank you. Mr. Rogaski. You talked yesterday about text messages between Mr. Crumbley's son and his friend.
Correct.
You talked about the amount of text messages that there were.
That's correct.
20,000 texts in 11 months, I believe is what you said.
Yes.
Now, are you familiar with how often teenagers text each other?
I have two of my own, so yes.
You know that teenagers text a lot?
Yes, they do.
Young people text a lot?
I'm sorry, what?
Young people text
Young
a
people?
lot?
Yes.
You don't know whether or not 20,000 texts is an abnormal amount of text between two teenage friends, or if it's an abnormal amount. Is that fair?
No, I've done teenage cell phones before, and that 20,000 is a lot for that time span.
In April 4th of 2021, you identified a text message between Mr. Crumbley's son and his friend, claiming that his dad told him, his dad being James Crumbley, told him to suck it up and gave him pills. Do you recall reviewing that text yesterday?
Yes.
Now, in that text, you don't know what Mr. Crumbley's son was talking about, that his dad told him to suck up. Is that fair?
Because I believe he told that he was not feeling well, or if you have the exhibit, I can look at it. I thought there was more context to it prior to suck it up, like then Toll just handed him some pills.
Right. You don't know what the pills were?
I don't know.
Could have been Tylenol.
They talked about Xanax before James and his wife did.
Not in that communication, correct?
No,
The one on April 4th of 2021.
correct.
There was also a talk about melatonin.
Yes, there was.
So it's fair to say that you don't know what necessarily was being discussed between Mr. Crumbley's son and his friend on April 4th of 2021.
Again, I thought there was more context before the suck it up, but I don't know exactly what they were.
Let me see if I can pull that.
Kurt, what do you think so far?
I'll pull the exhibit and we'll come back to it.
Fine.
I mean,
No objections.
night and day though, right?
I certainly like her a lot better. She's a lot cleaner. She's a lot more direct. And to my taste, the first lawyer just came off as completely exasperated, constantly and frantic.
Yeah.
It was like some bad trope, about like
Female attorneys or something.
Well, no, just like the overworked female trope. This woman who is just constantly frantic because she has so many things going on in her life, just moving from one thing to another, and
That's totally
just
what
high
she
energy
was.
and just always moving around.
That's why it was so triggering for me when people would say it.
Wendy,
What?
I
Say
did
what?
not read the new members. I'm sorry.
Like when they would call it out and be like, "Oh, this woman," and I would be like, "Stop talking so bad about her."
I did see. I was going to go over it at the end, Wendy, but thank you very much. But I mean, even trying to point out like he doesn't.
I'm confused.
know
Are
this-
you
this
offended
specific-
that I mentioned that?
No. During the actual trial, like while it was going on, and people in chat would be like talking crap about her, and it was just for some reason because like I do sympathize with her in ways, so it was I had to like
When
defend her.
McKinley is in trial, that's how she feels on the inside.
Yes.
The
And so
the
I was like,
difference is that
leave
it's
her
on the
alone.
inside.
But
I've known
I
many
agree
great
with
female
Bob.
attorneys and
I
many
agree.
shit men ones. It just happened to be that day. But whatever. I appreciate that.
Yeah.
Sorry.
Yeah, no, I definitely I feel like her most of the time, I should say.
But you keep it on the inside.
On the inside.
And this attorney could be feeling the same way on the
Exactly.
inside. But my point is she's hitting like her obviously her point she's trying to make right here is that this witness has no idea the context of these text messages. And I think she's doing a good job at pointing that out. And she pushes it probably a little too far a little bit here coming up. But again, the point's made. This guy knows none of the context, just the words on the page.
And the same thing on April 5th of 2021 with the friends. You don't know what the context of the conversation was. You just know what you're reading on a page. Is that fair?
What were they talking about on April 5th?
We'll pull that exhibit and I'll come back to it
Okay.
too. I was gonna do it on the screen, but it's not working.
Does that make a
If
difference?
you want, this one was flashing, but we can try it.
It's okay, Judge. We'll move on.
I think you can probably see it from either one of these angles anyway.
You talked about in exhibit 70 and 71, and I will pull those for you right now. Well, one is a placeholder because it was a video, if you recall.
Oh,
Mayor
yes.
Coach, Your Honor?
Thank you.
You're welcome. Exhibit 70 and 71 were a video sent from Mr. Crumbly's son to his friend, correct?
Correct.
And that was a video at 9:31 p.m.
That's correct.
on August 19th of 2021.
Correct.
We saw the video yesterday. It was of Mr. Crumbly's son handling a firearm.
Correct.
You hear the clicking. You hear it clicking in the video, if you recall.
After you loaded the magazine into it, yes.
You don't hear any voices,
No.
no other sounds.
No.
In Exhibit 74, you identified that was a GPS location showing that James Crumbly was at the home
Correct.
at the time that around the time that this video was taken.
That's correct.
Now, from the video that we saw, you don't know if James Crumbly is standing next to his son, correct?
No, I do not.
You don't know if he was standing across from his son, correct?
I do not.
You don't know if he was in a different room and had no idea that his son was handling the firearm, is that correct?
I can't say that because when you rack around into a gun, that slide going forward makes a loud noise. And in a small house, you'd probably hear it.
Probably, but you don't know.
For sure, with him, no, I don't. But it's
And you
likely.
don't know just by looking at that exhibit what the surrounding circumstances are of that video, is that fair?
What was going on around it outside the video? No, I do not.
You know what that video shows.
Correct.
And that video shows Mr. Crumbly's son handling a firearm and loading a magazine into it, is that correct?
Correct.
Exhibit 72 and 73 are also, if you'd like to look at them, there was also a text message between Mr. Crumbly's son and his friend. Again, it's another placeholder because it was a video. Mayor Coach, Your Honor? Sure. Thank you.
Thank you.
And that was a video sent to Mr. Crumbly's son's friend at 8/20/21
Correct.
at approximately 12:30 a.m.
That's correct.
In the text, after the video was being sent, Mr. Crumbly's son said to his friend that his dad left a gun out.
Correct.
You don't know if that's true. Is that fair?
I mean, I don't know why he would lie to his friend that he talks to all the time.
You don't know if it's true, correct?
From this, it doesn't say that it's true or not, but I don't know why he would lie.
The words on the page are the words on the page. Is that
That's
accurate?
correct.
See, I like how she just stops him and says, "You don't know that that's true." After he's like, "Well, I don't know why he would lie." He's like, "But you don't know that that's true."
Right.
Yep.
It's just so much more succinct, and
It's proper cross.
it really is, and it's pointed.
She's better.
She's just better, and we're pulling out things such as the father telling Ethan to suck it up. We're not dwelling on it for 20 minutes. We're not saying the word "suck it up" or what that could mean for 20 minutes. We're not getting into the locations of who's where when these firearm videos are made. We hit them real quick and we move on to the next thing.
I also like where she was doing the thing about could they have heard it? He's like, well, in a house that's small, it'd be hard not to hear it. But it's like, you don't know that. And he said, no, you don't know that. And then he tried to amplify his answer. He's like, no, I don't know that. And he's like, but, and she immediately said, thank you, and moved on to the next question. She wouldn't let him finish the answer. Very, very nice. Good job.
Yeah, I really like this cross. I want to play a little more of it.
You can't go back in time and get the answer, correct? You can't go back to August 20th of 2021 and figure out were you telling the truth that day?
Go back to that day? No,
Correct.
you could ask the person that sent the text.
Right.
Oh, you could ask Ethan.
Exhibit
He's not allowed to
76
testify.
shows that James Crumbly was at the home at that date and time. May I approach again, Hunter? Sure.
I
Wait, what
just
happened?
like that.
I wasn't
Except
paying
We
attention.
could know all this stuff if we heard from Ethan, but we haven't.
Is that what she
We're not
said?
going to. No,
He
but
said,
that's what he said.
Oh,
If you ask the person who sent the message, who is Ethan,
yeah. That's funny. That was stupid.
Why couldn't Jennifer have this attorney also? Because they were conflicted out. They were materially
Right.
adverse to each other.
Yeah, materially adverse.
Yep.
76 is again another GPS location showing that James Crumbly was at the home on August 20th of 2021 at 12:30 a.m.
Correct.
And again, in the video that was shown, you can hear the clicking sound. I'm sorry, this was the loading of the magazine.
That's correct,
The other
yes.
one was something else.
And just, yes, recorded it.
Exhibits 72 and 73 is.
Sorry, I just wanted to stop this. I don't think this is the right witness for that, because he has no personal knowledge. And again, you'd be asking him to speculate. I don't know, Kurt, your thoughts? Because James does have a hearing problem. As far as, could you have heard it? Could he have heard it in the room? Sort of.
Yeah.
Question.
Could he have heard what?
The racking of the gun in the video.
Where was this video taken?
It was taken supposedly in the house. And at the time, there's two videos. One, Ethan is looking down the barrel. The second one, he's like racking the gun, playing with it. No, yeah. And no, I got those reversed. I'm sorry. The first one is him racking the gun. And this guy's saying that at the time, James is in the home because of his Google GPS tracker thing.
Yeah, but like that doesn't actually mean he's inside the home. Just means
Well,
he's
I mean, it could
on the
mean he's
property.
standing right there next to him too, right?
Wait,
he's
what'd
not
you say?
It could mean that James is standing right there next to him, which means he's not an unsupervised minor with a handgun.
That's true. Good point. You're smart, Dave.
Mr. Crumbly's son loading the magazine into the firearm,
Correct.
and you hear that,
Yes,
and you see it on the video.
correct.
You can hear kind of like a whirring, maybe like a fan or something in the background if you recall.
I don't recall that, but, okay.
You don't recall hearing voices?
Anybody talk at the time?
Correct.
No.
No other sounds other than the loading of the magazine.
And the slide going forward.
And again, you don't know whether James Crumbly was standing there or not.
Correct, I do not.
You don't know if James Crumbly was in another room
The GPS says he was in the
and
center
the
of the house.
residence, correct?
Yes.
You don't know if he was maybe standing outside. You don't know, is my point.
The video just limits to the gun, correct, but the GPS puts him at the house at 12:30 at night.
If you were to say, well, this is what I think, and you said it similar to some questions a little bit earlier, well, the sound of the slide moving forward is loud and you would hear it in a house that size, that's an assumption that you're making, correct?
I've loaded a gun several times and it does make a loud noise.
You don't know whether or not
Exactly.
anyone is, I'm sorry, I interrupted you.
No, it's okay. You would know what's happening. And I mean, if you have a house that's large on the second floor, then you probably wouldn't. But in a smaller house, it does, you get metal banging together. It makes a loud sound.
You don't know, based on those exhibits that have been admitted, whether or not James Crumbly heard that sound.
Whether he heard it, no.
You don't know whether or not he was aware of it.
No.
You don't know if he was aware of it and standing right there.
Correct.
You don't know.
I know the GPS puts him at the house.
Strictly puts the phone at the house.
Exhibit 79
Yeah.
was
that's true.
a chain of text messages. May I approach, Your Honor?
Sure.
Thank you.
Thank you.
You're welcome. Is a chain of text messages between James Crumbly and his son's friend's father. Do you recall reviewing that yesterday?
This is part of new evidence that didn't come in under Jennifer's trial, because this is a text from James to, if you guys remember, Ethan's friend went away to OCD camp in Wisconsin.
Yeah.
And so these are messages from James to James's father. And what's very interesting about this is that one, they wanted to kind of keep it a secret from Ethan as to why he went away. His friend's dad said, please don't tell him exactly what's going on. But two, Ethan was trying to get a hold of him. James reached out to the father because, hey, Ethan's trying to get a hold of his friend and he's not responding. What's going on? So to me, it sounds like an involved active father, right?
Mm-hmm.
Correct, yes.
James Crumbly's son's friend's father.
Yes, I want to, yep, yes.
You reviewed the text during your investigation in this case.
Correct,
You looked at them yesterday.
that's correct.
This is the friend that Mr. Crumbly's son texted with so much, the 20,000 texts.
That is correct.
Mr. Crumbly was checking in on his son's friend. If you
Yes,
can
correct,
look.
yep.
Okay.
That's correct.
He was concerned because it had been brought to his attention by his son that he hadn't heard from his friend, if you recall.
Yes, correct.
if you recall from the text messages, the son's friend's father asked Mr. Crumbly not to say anything about the whereabouts of his son.
Until he went to the hospital?
Correct.
Correct, yes.
And he said, wait, and let's see how my son wants to handle it.
Correct.
I just find this cross so sharp.
In the conversation at that point between Mr. Crumbly and his son's friend's father, there was no expression from reviewing the exhibit. There was no expression of mutual concern about Mr. Crumbly's son or sharing any information like, yeah, my son's been having a hard time. Or there was nothing like that in that exhibit. And you can look through the pages that you have.
No, there was not.
Okay. On November 30th of 2021, in that same text thread, the friend's father texted Mr. Crumbly and said that he was praying that his son made it home okay.
On what, in here?
Yes, November 30th of 2021.
Correct, yes.
And that was after the shooting at the high school.
That's correct.
So this friend, the father of this friend that Mr. Crumbly's son had texted with so much, 20,000 texts that they had talked about, his own son had mental health issues, we see from the text. Even he did not suspect that Mr. Crumbly's son could have been the person responsible.
So that's speculation. As counsel pointed out, this witness can testify. Thank you.
Mayor.
Yes.
See, she got the question out. There was an objection. It was sustained, but the question is still out there.
Mhm.
Even this guy, who has experience dealing with kids with mental health issues because he just sent his own son away, didn't think anything was up with Ethan. No, I don't know. I really like this cross. We don't need to play much more. I just wanted to do a
No, she's
compare and
good.
contrast. Yeah.
She's very good.
I really like this
It's
attorney.
because like on cross, because you get to ask leading questions, they really should be a lot tighter. And you should be only asking very small questions that you know, like that you want a yes or no to, basically. Not what Shannon does, which is like go around and around and around and around in a circle. It doesn't have to be yes or no, but like you don't want it to be all over the place.
Well, even that last question is a perfect example, or I should, one of the first questions once Kirk got on the panel, what was it about? I can't remember, but it wasn't the answer she wanted, and she just moved on.
Yeah.
You don't dwell on it because you know you're not going to get the answer you want.
Yeah, good point.
So you just move on and direct your attention somewhere else.
Yeah.
No, new
She's very
evidence
good.
is not allowed to be presented in appeal except for exculpatory evidence. Well, it's not even.
Isn't that new evidence?
Kirk could probably answer this question better than I can. But if it's exculpatory and it's recently discovered, that sort of thing, right?
It would have to be evidence that not only was recently discovered, but due diligence would have not allowed to be discovered. So if through the exercise of due diligence you could have discovered, that's on you. It would have to be completely novel evidence. So good luck with that.
Yeah. So generally, no. I think Jennifer has some evidentiary issues that could go up to appeal and very likely could result in it being kicked back down, specifically parts of the journal that were not admitted when other parts were.
I still have no idea how we're getting the journal in. People have continued to explain it to me. It makes no sense.
It doesn't make any sense to me either, but I want an opinion from the Court of Appeals that says either all the journal comes in or none of the journal comes in. Either way, you're doing a trial over.
Yeah, it's a little bit hard how some of it is and some of it's not. That doesn't seem to make sense.
Right.
I don't get it.
Yeah, I have no clue.
And the text messages to the friend. It's like I'm planning on telling my father this. I'm like, present sense impression? I don't think so, Tim. That's not what I learned in law school.
I know. We have a loose interpretation, apparently. But no, so the text messages, all the hearsay stuff, really, the journal entry and the text messages, those are the two big things.
Also, putting aside the hearsay rule, there's just a massive confrontation clause issue as well.
Well, that's a bigger one.
That's even the bigger problem. How about the Sixth Amendment? How about that one? I seem to remember that one.
Yeah. So essentially, we have what we're talking about here is you have the right to confront the witnesses against you. But since we're admitting text messages and journal entries written by Ethan that are essentially condemning the defendants in this case, and they don't have the opportunity to
It's testimony from
cross-examine
Ethan.
that witness.
It's essentially, it's exactly what it is. It's testimony from Ethan. Like text message to a friend. Yeah, I'm going to tell my father all about it. So therefore, that's true that I did in fact tell my father. So that's testimony that I now have the right to confront, but I can't call him to the stand, which means you can't offer it as a okay. I'm mad. I'm mad. This is my fat mad face. Grr. Grr.
Has your mic been messing up all day?
Has my mic?
Oh yeah, your mic's crackling. I thought that's what you were mad about.
Oh, I didn't know that.
Crackling. Yeah.
I had no idea.
Let's see here. Oh, by the way, so while Kurt is fixing his thing, let me just get to these.
Do you have a Rodecaster, Kurt?
No, I have a Shure SM7B.
No, I know, but like the thing you plug it into?
I have a Focusrite Solo.
Okay. It sounds like what happens to mine when my earphones are like coming out, kind of.
Wendy with 10 gifted memberships, and then Murph's Turf with 5 gifted memberships, and then another 5 gifted memberships. I appreciate it a lot. I'm sorry I missed the reading of the names. I don't.
All right, let me know if it gets any better.
I can't.
That's better. That's way better.
Easily. Yeah, that works. So, but yeah, so this is what's interesting about this trial is I feel like we get to see it. I recently saw Wicked last month. My wife wanted to see it, and I saw it years ago, like 15 years ago. And I was really excited for her to see it because I loved it when I saw it 15 years ago. And the actresses that were portraying, I can't remember their names, the Wicked Witch of the West and Glenda, the Good Witch, weren't the same. Obviously, it's been 15 years. And they were a little different. And it's not the way I remembered it. And it wasn't as good, in my opinion. So I thought it would be fun this is the same kind of thing, right? We have the same fact pattern. We have the same prosecutor, same judge, same witnesses, same testimony, same evidence, but we have 2 different roles being played by the defense counsel. And so this is a lot of fun to kind of go back and forth. And that's what I'm hoping to do for the rest of this trial is look at the comparisons between the defense attorneys and see if it really does make a difference. This is kind of like a little experiment. I feel
it's so obvious now.
Right?
Poor Shannon.
What I say is like, you can be a really good attorney, but have bad facts and lose the case. Mm-hmm. Or you can have really good facts and be a bad attorney and lose the case.
Mm-hmm.
And so I'm wondering if James gets acquitted and Jennifer's convicted, mm-hmm. It's still anecdotal, but it's still kind of a fun little scientific project I'm playing here. Take care, Lefty. Thanks for stopping by.
Bye, Lefty.
Have a good evening dealing cards or whatever you're doing.
Hey, Tanina.
So Kurt, you didn't stream it all today. Are you going to stream tomorrow or anything else of this trial?
On Saturday? No, probably not. I'm thinking about trying to do the Supreme Court. I want to do either the second arguments in the Net Choice versus Paxton case because I did the Florida half, or I'm going to do the merit briefs in the Trump immunity case.
Okay. What'd you think of the Colorado, the Supreme Court's opinion on Colorado? Did you read over that yet?
I enjoyed watching the left tiers. That was a lot of fun.
All right, fair enough. I haven't read the opinion yet. I
enjoyed watching. I enjoyed watching the expert pontifications of The View. They were scholarly and informed, and I enjoyed watching their critical analysis of the decision. It was very fun.
I'm sure it's something that I have to go back and watch for just to soak up the knowledge that is the collective gaggle of The View.
I thought the minority had a pretty solid point, though, on the question. It's an interesting question because it doesn't necessarily have a clear resolution on how much more than the strict confines of the question should you solve, because the minority was correct that they didn't have to really speak to the federal government issues at all, which the majority did, in order to decide the state issues. So they went beyond
Who
what they
wrote the
needed to.
opinion?
It was technically unsigned, but it's Roberts. I mean, I've read enough opinions. It's Roberts.
Okay.
Yeah.
I was curious as to who wrote the opinion. I haven't even I've downloaded it, but I haven't read it yet. I was going to do a stream about the Alabama Supreme Court decision because the media is like portraying this as something that it's not.
Yeah, I covered that case too on the statutory interpretation, and I'm not sure if I agree with them, but that's what they have precedent along those lines, because it's an issue of statute that says that effectively that because it's a wrongful death cause of action, it's a civil
Right.
wrongful death cause of action, and the statute says that, or at least the prior interpretation of the statute says it extends to every stage of life. So if you cause wrongful death at any stage of life, including in the womb, then that's a civil wrong, which that idea isn't inherently ridiculous because, depending on the circumstances, you can get murder for killing the child in the womb because it's recognized under that same sort of status. So what the Alabama Supreme Court was trying to decide is, does the location of the fertilized egg matter? If the fertilized egg in the womb counts, which they already have, does the fact that it's not in the womb mean it no longer counts? And they decided that the location wasn't the thing. And it's like, well, that's a reasonable interpretation, I suppose. And that's what they said.
And so wait, what are we trying to decide? All I heard was
so
fertilized egg,
Alabama,
fertilized
like
egg.
most states,
Was I not clear, or was I
I wasn't.
vague, or-
I wasn't paying attention. I was
I'm
looking at your
sorry.
So
TikTok thing in the
most-
background.
Oh,
most states have a law, a statute that says basically if you kill a child inside the mother's womb, you're essentially that's
Right.
murder or manslaughter or some sort of form like that. And so Alabama has something similar. But what's interesting is the fact pattern is that there were two couples and they both had fertilized embryos of various amounts. And somebody, like a stray patient, went into one of the places. I remember they like picked it up and dropped it and like killed the embryos. And so these parents sued under a bunch of different counts, breach of contract and all kinds of other stuff. But one count was
Wrongful death.
Wrongful death as a civil action. And so the narrow issue was, under the statute, we're going to say that killing a person at any stage of life is wrongful death. Does it matter that they're not inside the womb?
Yeah, right.
And the court said under the statute, the location doesn't matter, as Kurt just says. It's a life under the statute, so therefore it's a life, and they're entitled to wrongful cause of death action. But then everyone stops, the in vitro fertilization, all the companies that do that stop it. They stop it because they don't want to be freaking sued for causing the death if they screw up. That's why they stopped the
Not only that, what about the fact that so I think this is the way it works. When you have like the fertilized embryos and you're storing them, I think they freeze them.
That's exactly. Yep.
And then when you're no longer going to have kids anymore, right? Some people sign it like they're destroyed.
That's actually a good. That's a very.
So is that murder?
Do these companies then, under this interpretation, have to maintain these things forever and ever and ever?
And that's weird. And also,
they didn't talk about that.
Not
though,
sustainable.
They didn't even anticipate that issue, did they? In the opinion, I don't remember hearing about that.
And by the way, because someone in your chat is confused, and I'm trying to correct them twice, the court's decision did not cite God or the Bible at all. Now, some of the individual justices, when they were writing concurring, mentioned it, but the court's decision did not. It did not rely on religion at all in the court's decision.
They cited
That's the thing is
God.
In one of the concurring opinions they did, but not in the court's decision.
Yeah.
Huh. Okay.
The court's decision literally just looked at the statute. The other thing too that I wanted to point out is that all sides, plaintiff and defense, all agreed that this statute says what it says and means what it means. The only question was, did it apply when the embryo was not in the uterus? That was the only issue. Otherwise, everyone agreed on what the statute actually said too. So the in vitro fertilization or fertilization company, whatever it was, there's two companies. One was a medical facility, hospital, whatever. They all agreed that this statute applied if the embryo was in the uterus. They just disagreed whether or not it applied outside of the uterus. So that was the fundamental question that the court had to answer. And
they decided it did. It does. It still apply. It applies. But that makes me curious about, like, I don't know how they're gonna. I just don't understand how that's not gonna be, like, murder.
Yeah, the only rule I have in my chat is that no personal attacks unless they're against me. Otherwise, you guys can. Yeah.
Can I write? Can I write what? Can I write to this guy who's trolling me that he's an illiterate fuck, or is that too much?
Sure, go for it.
Okay.
Yeah. So that's my only rule. Otherwise, my mods know the rules. No personal attacks. You guys can time out, whatever. Do your thing. But yeah, so that was an interesting opinion, and I was actually going to do a stream on it, and then I just got tied up with work.
Whoa.
But no, so that and the Supreme Court decision in Colorado, I want to read that. But am I right then, Kurt? Then I don't know if you've read it yet. Is it like the bulk of this stuff that they're being criticized for in the concurring opinion? Is it just like random dicta that they're putting out there, or?
Not even so far as it's dicta, and I'm not even sure necessarily it's wholly inappropriate, to be quite honest, because I mean, it depends a lot about how you think about such things, but it's not necessarily uncommon for courts to cite religious texts or things that form part of the foundational values. But it's not even technically dicta because it's just a person writing for themselves. It's just a person expressing their own views about the thing. So yeah. But as to whether or not it will impact IVF or not, I mean, that's up to obviously the IVF facilities and whatever agreements they do or do not have with the patients and the extent to which they can waive claims, because it's just a civil cause of action. So presumably you could waive claim with a sufficient waiver, and you could also get the legislature to deal with that separately. So I don't know if IVF facilities have in fact closed down in Alabama or not, but that was.
I don't know. I just heard like the news media was going crazy, like we can't get our in vitro fertilization stuff, whatever. I keep pronouncing it wrong, but so I wanted to read the opinion, and if they are shutting down their operations, it's because they don't want to be responsible.
Well, they didn't say that. They certainly didn't say anything about shutting down IVF in their opinion.
No,
they didn't say anything like that at all.
And it wasn't like banning it at all. It wasn't, it wasn't abortion related. It had nothing to do with any of the stuff that's all being put out there in the media.
But that's kind of what's weird to me, though, is like, I don't even remember what I was going to say. See y'all? I distracted myself with my own shit again. Hey,
Fedorowski. Good to see you. Yeah, so
the abortion and the murder thing are where I think that's going to be a problem, because if they're deciding that that's now like a life at that point, then I think they're going to have to keep them forever eventually. In Texas, they could move that way. I don't know.
Yeah.
But I'm also a bleeding liberal, so of course I would think that.
Welcome, Viking Raiders.
That's the prerogative of the states. That's what Dobbs does, return it to the states. So states can take any position they want on these issues now. So they can allow all abortions up to the moment of birth, or allow no abortions, or somewhere in between. And one of the things I think that was good from a sort of meta policy is it just brings back the individual decisions of the states to actually have debates on what they actually think about these issues. And people are taking all kinds of positions in the immediate aftermath, but I don't know what happens in the long term. I'm not particularly confident that, absent federal action, which I would oppose because I don't really see an action for Congress here at all. But I don't really see that in 50 years' time we're all pro-life, we're all pro-choice. I'm not sure where this is ultimately leading.
Oh no, hell no. I mean, the whole country's definitely not all going pro-life or pro-choice.
The beauty of our nation is that we have 50 states to choose from, and all those 50 states can have different priorities and
Right.
different structures and different
Just
legal
sucks when you
positions
took
on
the
different
bar and
things.
won, huh?
Well, fortunately, unless you're
Oh
getting
yeah, you
down into
took
the
it.
weeds, it's all well. Yeah, that one I recently took the bar because I took the
Yeah.
to get into Texas, so I took the UBE. So I'm now eligible to be licensed in something like 40 states.
Oh,
So
nice.
I got that going for me.
Nice.
Nice. Well,
I'm a huge states' rights proponent, and I said Colorado did it wrong. I believe under Article 2, Section 3, the states absolutely have the right to choose who goes on the ballot because they can just decide under state law that they're not going to have a popular vote, and the governor's got to pick the electors. It doesn't matter. And if the governor picks electors that are not going to vote for Trump, then so be it. It's 100% up to the states.
Yeah,
They
I mean
should
they
have.
can forego
they sh-
elections entirely. I'm
Yeah.
not sure. I'm not sure whether or not having made the decision to do it by vote, they can
no.
make the kind of choices you're making. But they could make the decision to not have a vote at all and just give their electors any way they want. That'd be fine.
It would be absolutely fine. But at the end of the day, I think the state has the final decision as to how to conduct the elections for the electors that are going to vote for the president. And the federal government has zero role in it. And by citing the 14th Amendment, they actually shot themselves in the foot because then it created it as a federal issue as opposed to a state only issue. So if they had just gone with Article 2, Section 3, we wouldn't be having this conversation and Trump wouldn't be on the ballot in Colorado. So I'm a huge proponent of that. It's up to the states.
It's certainly a more interesting legal theory. I like it.
I like it too, and I want more states to adopt it, regardless of the chaos that will ensue. But that's been my opinion from the get-go. They screwed up by citing the 14th Amendment. And the only logical conclusion was that the Supreme Court was going to make the decision that they made, that Trump had to be on the ballot. They could have gone it a much easier way, and they could have been successful in that.
All right. Well, let me sign off for now. I'm going to do my own stream in 20 minutes, and I want to take a break.
All right. Take care, Kurt. Thanks for joining us.
Thanks for letting me drop by for a minute.
All right. No problem. Take care.
All right. Bye. Till later.
Everyone go check out Kurt. I'm going to put this link in the chat, or I mean, not in the chat, in the description below. So you guys, if you don't know Kurt, you guys can go check out his stream. But yeah, so that's our random derailed towards the end of the Crumbly stream. Anything else to add about Crumbly at all, McKinley, that you have, other than hopefully this poor guy gets to go home?
Yeah, he's not going home. I hate to tell you that.
Somebody said in my chat earlier that they think James was pushed around a lot by Jennifer and was maybe kind of railroaded and just sort of kind of like did whatever to make her happy. And that, I feel like that could be what actually happened, and that he's not as
I definitely think that is what happened
as Jennifer. He might get acquitted.
The problem is, well, I guess we're not in Jennifer's trial, right? So the facts are going to be different on when it comes to his case, obviously. And also that one juror said that like she was the last one holding the gun case, the gun, whatever. But I remember that she said that it was his responsibility to put the gun away. So you think the state is going to try to use that? Can they use that?
Well, they can obviously use Jennifer's testimony because it would be hearsay. And she's not going to be testifying.
Right.
So presumably, no. They're just going to go through the same motions. Hey, it worked the first time. We'll do it the second time. But the big difference here is going to be this attorney, if she can make it work.
And since it's her that had the gun walking out of that place, and they're not going to have the testimony. I mean, I don't think they're going to have any testimony about it was him that was supposed to put it away or secure it that night, right? Then she's the one who was having the affair, if they get into all that, and like, it does make it seem more like her fault.
It does. And I mean,
I do too, Murphs.
Hey, welcome, by the way. Vin's Vince Gortho. Ha, got it. Vince Gortho. Awesome name. Welcome. Check out my member tab, which take you to a link for my Discord where I have a lot of my member content, and go have fun in there. But welcome very much. And Wendy, I'm sorry, and Murphs, I'm sorry I didn't get to reading the names. I have a new setup, and it's only the one monitor. I have a second one temporarily, and so I don't normally have my like I usually do. I have my chat from YouTube up so I could read the names, and I don't have it up right now, so I missed all the names. But I do appreciate the gifted memberships. I think moms are held to a higher standard than dads for caring for their children and know what's going on with them. And that could be the thought. We have 15 jurors. There's only going to be 12 that go back, but right now it's 6 men and 9 women. So maybe they'd be more inclined to say dad wasn't so much involved and he's therefore not so much culpable. But we also have, like his attorney was just pointing out, text messages from James, initiated by James, contacting Ethan's friend's dad about, hey, what's going on? Ethan's worried because he can't get a hold of his friend, showing an involved father. So I don't know. We'll see. We'll see how it goes. Hello. That's about all I have to talk about today.
Stacy,
Is this yours?
you. I think so. I don't know where she originally came from, but I started seeing her during the What the Hill stuff.
Okay.
But it is nice, and I love her name, right?
Yeah, nice.
Stacy.
I like that. Stacy. It is true. Texas can be split into. I believe that's still possible. There was an opportunity for Texas to split. The opportunity is still there. What I mean by opportunity is they missed their chance to split and not create 5 liberal states, primarily Democrat states focused around the Democrat hubs of.
But she
Texas.
said countries.
Oh, countries. I'm sorry. I was thinking states. No, that's out the window.
I mean, that was settled with the Civil War.
Yeah, it really was. Texas was absorbed in the Civil War. But when they were first admitted to the Union, they had the opportunity to split into 5 different states. That's what I thought she was talking about. And there was talk about doing it in the 50s, in the 1950s. And it could have, but it was blocked because it would created 5 really conservative states. And now it would create 5 really liberal states. So they decided not to do it.
Yeah. Ellie over here thinks that Texas should become its own country, but get rid of their biggest cities. Then they're going to be like,
imagine what a different country this would be if California just said, we're going to do our own thing and become a different country. Be like, all right.
I'd move there.
See ya. When you move to California,
jump right over.
You're a liberal.
I'd jump right over. No, I wouldn't, because I don't have enough money.
Yeah, but you could walk there. It's not that far. You're by Carlsbad,
it's so far.
I don't know where you're at. Where are you?
I'm in Austin.
You're in Austin, okay.
Yeah.
I've been to Dallas and I've been to Houston. I've never been to Austin.
Yeah, I think I'm in the middle, maybe. I don't know. I should know what Texas looks like better.
Okay, so you don't know if Austin is between Dallas and Houston?
It feels like it is, but I don't know if I'm going to look it up. I don't ever go to Dallas.
Let's please look it up. Let's please educate McKinley on the geography of her own state.
Yeah, kinda, but not really. I guess you can get from Houston to Dallas without going. Like, you definitely don't have to go through Austin. It doesn't look like. Anyway, I think you take like 45 from Dallas to Houston, and 45 doesn't even run through Austin, so that makes sense.
Why is Google Maps being all kinds of weird?
I don't know.
I've also been to Galveston. Yeah, no, it's nowhere near each other. What are you talking about?
I love Galveston.
You don't go. You have to like go out of your way into like a little triangle.
Yeah.
Just so you know. So here's Houston, here's Austin, and Dallas is up here. Or wait, where's Dallas? Yeah, Dallas is up here.
Yeah, it looks like to get to Fort Worth, it would make more sense. I've definitely been to
Fort Worth, Dallas.
Yeah.
Or Dallas
Yeah.
Fort Worth is the name of the airport.
Yeah,
they're
but
right
like
next
see
to each
Fort
other.
Worth, the other city that's next to it on the left.
Yeah.
Like I think that one might be on 35.
This
I
looks
could
like
be
one
wrong.
giant city. That's not two cities.
Was that on 35? No, it's 2 cities. Zoom in.
Zoom in. Zooming.
Okay, and go to the left.
Wait, what's your address?
Shut up. Zoom in again. I want to see if that's 35. Does 35 go? That's not,
Enhance.
is it?
Enhance. Enhance.
What freeway is that?
I don't know. That's 30. That's 30. That's 30, and this is 35 west. This is 30 and 35.
Oh, really? So 35 is
goes
there.
north and
So
south. It
35
goes
is
up
there.
and down.
Yeah.
Yeah, 35 goes up and down.
Okay, so you can take 35 from here to Fort Worth.
So where's your
And
house?
Fort Worth, Dallas are the same, like, like you said, they're the same city, but they're not. But
They kind of are. So are you in like Austin proper, or
yeah,
you
I'm in almost
Austin?
in downtown Austin.
Yeah. So you all right. So where's your house?
Yeah, I'm very close to the lake. Well, it's really a river, but it's been dammed into Lake Austin.
Lake Austin. Where's Lake? Is this Lake Austin?
I mean, the whole
Mm.
Colorado River is different parts of the lake, but if you go to Austin and then
I'm
downtown,
in Austin. I'm right
yeah,
here.
okay,
I'm
so
downtown.
yep, go to the left more. Okay, so when you get right
Oh,
there,
I hear.
Austin. That's
This
Lake
is the
Austin.
dam.
Yeah.
Okay, so you're over here.
Mm-hmm.
Wow, that's a lot of people. Look at those houses. That's a lot of people. Who would want
Yes,
to live like
sir.
that?
There's some very nice houses there, right there on the water.
Is this a
Yeah,
country
that's
club?
Muni. No, it's I don't know. It's called the municipal.
It's a municipal.
course.
It's called Muni.
Yeah, I always wear a shirt that says Muni on it.
All right, so this stream has officially been derailed.
Sorry.
I was trying to dox her, but she wouldn't give me her address. She's
Let's
gullible
not.
enough to have, but she didn't. All right. I love having McKinley on with me.
Yeah, I've missed you, man. I quit streaming when you quit.
Did you really?
Yeah, I did. I was like,
Valhalla knew what I was doing.
yeah, I know. I knew where we were going with that, but that's real dangerous, you know.
I know. I wouldn't have let you done that.
I want to go, Zach. I keep telling you this. Take me on your
Lake
boat.
Travis next weekend.
Yes,
What's
I
the
keep telling him
temperature
to
down
take me on his boat. I don't know, but it doesn't matter. Every temperature is a good temperature for the lake.
46 degrees. That's what it is right now. I feel like that's a little cold.
Where?
Here in Michigan.
Oh, yeah. Maybe a little cold.
Thanks everybody for joining me. McKinley's link is in my description of this channel. Go check her out, or of the stream rather. Go check her out. Monday at 9 a.m. I will be streaming the Crumley trial again without commentary again, and then I'll do another 6 p.m. sort of recap stream. Again, I'm really focusing on the cross-examination because everything else is the same. I might, if the defense actually has a case in chief and is actually calling witnesses, if I can swing it, I will stream with the commentary because that'll all be brand new. But otherwise, we're going to do the same thing like we've been doing. So check it out and go give McKinley a like and subscribe and go watch her stuff.
Don't watch today or yesterday. They were terrible.
I'm sure they were fine.
Mm-mm.
Oh, you're the one that emailed me, right? I emailed you back, and then I probably missed you. If you email me back, I want to talk to you. I want to get your notes and your thoughts if you were there today, just to see kind of like, is the jury sleeping or what's going on? It's all reading tea leaves and looking into magic 8 balls, but
where's the Discord link?
It's under my member tab. If you go to my main channel and you go to my and you click on member, there should be a link to Discord. If it's not working for some reason, it should. I don't know how new it is.
Because I think you have to do it every 7 days, or at least that's what MG says.
Okay. Well, then I'll post a new link. I'll post
Okay.
a new link as soon as I'm done with the stream.
Cool.
Where am I going to send you guys?
Oh,
Who's
that's crazy.
streaming right now? Who is streaming? Let's see here. Does MG have a stream coming up?
Not until like 9 something tonight. I don't think
Oh, it's so
9:05
early.
or something.
8 o'clock.
Oh, you know who has a stream? Expert. But I don't know what time.
Oh yeah. What time is the expert streaming? I might make an appearance depending. Oh, he's streaming at 9 too, so he's got an hour.
Oh, that's
I'll send you guys there anyways. The expert's
really?
awesome.
I hate doing that.
Why?
I just hate sending people to a stream that's not actually going.
Oh God. Okay, hang on, folks.
You
Can
know
I
what I
send you
mean?
guys to the lead attorney? Does he
Yeah,
allow
he's great.
redirects?
Oh,
If he
he's
allows
so fun. I
redirects,
love him actually.
tell him I said hi,
And me.
and if AV is with them, blow her kisses for me.
Oh, she's so awesome.
Yeah, AV's cool. Let's see if he allows redirects. Nope, no redirects. All right.
Yeah, I think I knew that.
You know what? I'll send you guys to the Young Jerks.
Yeah.
Young Jerks is streaming right now. I don't know what he's covering. He covers a lot of Turtle Boy stuff. Oh, I can't. You guys got to turn your stuff on so that I can redirect you all.
That's
and
annoying.
I'm sure the chat's yelling at me about something that I'm not paying attention
No,
to.
Nick quit and they came in. Oh, Gosney. They're saying Gosney.
Oh, yeah. Good call.
Good call. Good call,
Steve
Aaron Olivia.
Gosney. Steve Gosney. Yes.
Yay.
5 minutes. He's going in 5 minutes.
Well, we can hang for 5.
Yeah, we'll hang for 5. And then I'll send you guys over there.
Okay.
So what else you know what? Actually, while we're hanging for 5, we had some evidence questions posed in my Discord.
Oh yeah.
Where was that? Now I got to find it.
I can never find my way around there.
It was questions. I think it was questions for our leader.
Oh yeah, that makes sense.
Let's see. Nope, wasn't there. That was Lady Law.
Maybe on Crumbly. No.
Sandra, where did you post it? Your questions, because she had some evidence questions that I thought were really good, and I thought you and I could talk about that.
Okay.
Was it under Crumbly? No, she didn't post it under Crumbly. And where would you have posted it?
Are you reading?
I know in the Discord, but where?
Where in the Discord? On what tab? Or like whatever you call it, channel or?
Let's see. Yeah,
I went through and checked all of the. How do you get rid of those notifications next to watch party?
Oh, you got to go into the chat.
Oh, okay. Why are they saying hi to me like I was in here?
Don't know. Probably because we were tagging you to show up for something. Like, hey, come to the watch party because we want to show you something.
At 3:26 p.m. maybe.
Yes, that's probably exactly when it was.
Oopsies. Sorry.
Gossi makes me want to be a better human. He does me too. That's why I like keeping him around. You should always keep people around that are better than you so that it inspires you to be better yourself. That's why I like Gossi.
Law lessons.
Lessons.
I think she means it. Oh, never mind. I thought that was.
There it is. Okay. Got it. Okay. Okay. So how do we identify potential witnesses who may have relevant electronic information or knowledge pertinent to the case? So I don't know if you're asking civilly or criminally, because criminally, usually it's the police that are doing a lot of the legwork. And then they're kind of revealing some, if not all, the information. And then you start poking around, you start asking those people questions. And
can you say the question one more time?
How do we identify potential? Here, you know what? Let me just do this.
Yeah, that would be great.
You're getting all right. So this is our Discord here. I'm not supposed to be showing this, but I will do it.
Zoom in. Like maybe you can zoom into only the question. You know what I mean?
You know what? I'm going to do this.
Yeah.
Hang on. Let me paste this into a Word document.
Maybe stop doxing me while you're at it.
Yeah. There we go.
Thank you.
How's that? Is that better?
Yeah.
Okay.
Thank you.
So let me paste this into a Word document. And then what I can do is make the text nice and big.
There you go. Great.
And let me zoom
Perfect.
in.
Perfect.
How the hell do I zoom in here? Let me just do it this way. Okay. So how do we identify potential witnesses who may have relevant electronic information or knowledge pertinent to the case? So in civil, usually I kind of start broad and then I focus down. And so when I mean broad is I'll send an interrogatory that says, give me the name of anyone that may have knowledge about, say, this particular transaction, or give me a list of all your employees or whatever, things like that. I start very broad and then I start focusing it down with either depositions and stuff like that. And then I'll ask for specific, documents. And, if I want, say, a cell phone data dump, right, that kind of thing, I'll send a subpoena to, like, say, the plaintiff or something that says, show up at this date for a deposition and bring your phone with you because I have an expert that's going to do a data dump from it, an extraction, that sort of thing. And then we just start going through it. And then if I see a message to some other random person, then, I'll either use my PI to identify that person or whatever it is. And then I'll go send a subpoena to that person and say, tell me everything that you know, show up for this deposition. And it's basically asking questions like that. And so, like we do in Michigan, we do initial disclosures where we have to produce our evidence that we have ahead of time and our legal theories. But we always say this might change as discovery goes on. And you can always ask questions, even if they're not admissible at trial during discovery, because it might lead to more admissible questions. So, or, something that is admissible. So I always start broad and then start narrowing, focusing in things. That's what I do.
So
McKinley, thoughts?
I think in criminal cases, like, kind of the same thing. Actually not the same thing because we don't actually do discovery like that. We wait on the most of the time. We wait on the prosecutor to release their discovery, their evidence to us, and then we will start to go through that. A lot of so one time I was on a case where there were like 200 potential witnesses. A unaliving case that starts with an M. And because they were all high school students. And so of course they were all over social media. And so I looked all over social media following these accounts and figuring out who was talking to who. And then that's how we knew who to call as witnesses or who to have the investigator go and talk to. And then they would the investigator would get statements. And then once we had statements, they would become affidavits. And then we called them to the trial and had them testify if they were helpful. And that's how we did that. Other than that, unfortunately, a lot of times the evidence gathering comes from the state. So,
yeah, on the criminal ones, they really do. We don't have the right to do discovery and like deposition type stuff in criminal cases in Michigan. So it makes it really difficult. You can't like compel someone to show up to a deposition and answer questions. The only chance you really get to ask them questions is if they voluntarily want to talk to you. So it's kind of a pain on criminal stuff, at least in Michigan.
Yeah.
What method do you employ to gather and assess witness testimony in conjunction with electronic evidence?
I think I just answered that for my side.
Yeah, and the other thing I do too is, like, for example, I asked my clients the other day, I said, give me a list of anyone that could have any information about this particular incident. That would be employees, but other ancillary people too, anyone's name. And then I start making phone calls and I start taking notes and I'm like, I'm going to probe a little deeper into this, or I'm going to ask this person a little bit more. And if I feel like this is relevant, I might have them sign an affidavit or come in for a deposition. It's all about asking questions, constantly asking questions and constantly taking notes. And then so if they have text messages, for example, Like the particular case that I asked for, ended up getting information that a random bartender might have information. So I call up and talk to that random bartender. And I'm like, great, would you mind forwarding me screenshots of all these text messages? And so I don't need to do a data dump. She just sends me the text messages and they're in photos. But I can, if I need to have her testify, I can say, is this a screenshot of the text message that you received on such and such date? And she'll say yes. And so now it's admitted, that kind of thing.
So for that, do you make sure, like, so in my cases, I usually make sure that they go through and they like delete the person's contact. So that like they delete the contact so that the actual phone number will show up. So then you can say, is this your phone number? Or do you recognize this phone number? Rather than it, because there's no way to prove. Because if you put it in your phone, this is so-and-so, it doesn't mean that that's so-and-so. You can't authenticate.
Yeah, I know what you're talking about. I generally don't have them do it because the witness that's going to be testifying is going to say, I texted with this person. These are the screenshots from this person. Now, if it's a hostile witness, I won't get the information voluntarily anyway. So then I'll just do a data dump and then it doesn't matter. I'll just compel them to show up for a cell break extraction and we're done with it.
You can do that in civil?
Oh, absolutely.
That's amazing.
Yeah. No, I do that all the time.
Amazing.
So
that's awesome.
Yeah, I mean, I'm talking about friendly witnesses as opposed to hostile. The hostile ones, if I get their name, I'll just subpoena them and then have them turn up with their phone and I'll just do a data dump and then I'm not worried about it.
Yeah.
How do you handle witness interviews or depositions to ensure the collection of accurate and relevant information? It depends on the circumstance. For example, you might have someone that's going to be tipped off about it. So you might want to do a lot of legwork ahead of time. I had one guy that embezzled a bunch of money from his mom. And we brought him in to my office for a creditor's exam. So this is a deposition about his finances after we already had a judgment against him. We knew he had some bank accounts and we knew he has like some safety deposit boxes, but we didn't know where. So I had some employees that were sort of like hanging around, but weren't really involved. And as he was giving us information, I was texting them and they were running with subpoenas to the banks to secure everything while he was stuck in my office. So he didn't have a chance to hide things.
That's crazy.
And so that's an example of where we try to get the truthful information out. And so if they called me back and were like, yeah, there's no such account or something like that, then I could be like, all right, so my associate just said that they went to the bank while we were here and there is no such account. So do you want to tell me, where you actually have your bank account? That sort of thing. And so, or you could just, ask them a bunch of questions, follow up. And if there is no such thing, then you can find them in contempt of court for lying under oath and, have them thrown in jail or whatever. So there's a lot of different things you can do with that. Trust but verify at the end of the day. Oh, can you provide guidance on coordinating the discovery process to interrogate electronic evidence and the witness seamlessly? Coordinating the discovery process to interrogate electronic evidence and the witness testimony seamlessly.
Wait,
I had a crapshoot. I mean, I don't know what you're asking. Maybe this is it. Very much a crapshoot. I had a case. It was a family law case. It was a divorce. And the woman was saying that the child was homeschooled. And the woman was saying that the child is not neglected. She's actually being taught. My client was saying that the child just basically sits all day and plays video games. And so I was questioning the wife on the stand. And I said, well, what do you teach? What do you work with? And she's like, oh, we work with this program online and it has all these worksheets and it keeps track of her progress. And I was like, oh, great. So you can log in for me. And I literally handed her my computer. And she was like, oh, well, I don't know. I can't remember my password.
She pulled the Lynette.
And we said, oh, well, go ahead and reset it. And she's like, oh, but it'll send me an email and I don't have my phone on me. And we're like, well, where's your phone? And she said, oh, it's over there by my attorney. I'm like, here you go. And so we finally got her to log in. This is in front of the judge, live testimony of thing. Got her to log in. and this is a child who is 9. I think she was 9. And we looked at the progress reports, and luckily they were shit. There was like preschool and early kindergarten level progress reports. And we're like, this is messed up, lady. So it was a crapshoot, but it worked and got my guy custody. But I mean, if you do something like that, I don't know how else to do it seamlessly. A lot of our depositions are done via Zoom now too. So, and people can share screens. So
That's what I
if
was
we
gonna
wanted
say.
somebody to log in and share their screen and do all that, you could capture it all. It's all recorded, you know, video recording and stuff like that. So everything is captured as well.
I was gonna say, just tell the judge you need to use your StreamYard.
Yeah. Let's see. How would you recommend the
Corroborating
cooperating?
or challenging witness testimony using electronic evidence. Oh,
No, I just went through it.
yeah.
Have balls. Call them
Yeah,
out.
or when they get up on the stand and they start talking about how something went down, and yet you have text messages or you have Facebook messages to show the opposite, then you just impeach them with it.
Yeah, exactly. Let's see. How do you handle discrepancies between witnesses' statement and electronic recording discovery? I always ask one question. And I sometimes have asked it of my own clients when they're being deposed for something. Like, you've given a lot of dates and times and statements that you made. Now, if there was a writing or electronic document or an email and your dates and times and statements differ, should we rely on your testimony here today, or should we rely on those documents?
Yeah.
You know, that, and so that's the question I always ask them.
Yeah.
And
I don't get that option because we don't do depositions or discovery like that.
that's weird. What legal considerations should we keep in mind when preparing witnesses for discovery proceedings involving electronic evidence?
Don't erase anything.
Yeah, don't erase anything because it could be construed against you. So if there's something that did exist and it no longer exists, the court can actually take judicial notice that that would have been bad for you, and can actually tell the jury that. It can literally say, listen, this document used to exist. It doesn't exist anymore. So you, jury, can consider and are directed to consider that that document would have been bad for that defendant or plaintiff or whoever's, you know, deleted it. So don't delete. That's the big thing. The other one is get a protective order in place always when you're exchanging information. So that it's clear by court order that the only thing that this could be used for is this particular case and nothing else. So that's another thing you want to watch out for.
If the client did delete already, well, don't delete anything else. I mean, it's not going to be good because they can tell that it's deleted when they do the dump.
Yeah. Accidental deletions are always good. What legal considerations should you keep in mind? Okay.
Accidental deletions.
Can you assist? Well, because you don't want it to be intentional. If there's a deletion, you want it accidental, right? It's better than it being intentional.
Mm-hmm.
Can you assist in crafting discovery requests that encompass both electronic data and witness information effectively? Yeah, I actually have part of my standard discovery has definitions. So I do my normal little caption, and then I say, this is issued pursuant to these court rules. You have 28 days to respond. And for this discovery request, all these definitions apply. And it's like 2 pages worth. But a lot of it goes into computer means this, data means this, computer file means this, you know, and then I have a bunch of these acronyms for different types of data. And so I define a document. And when I say a document is a piece of paper, it's an electronically stored piece of data, it's, you know, and I go through this list of what a document is. So then when I actually get to the question, turn over all documents, it means all these things. And so I'm able to, under my court rules, just to incorporate that into the definitions. And so I just make sure that it's as broad as possible, because I'd rather have too much information than not enough. I don't know about you, McKinley. Are you able to even ask for electronically
I
stored
mean,
information?
yeah, if it becomes a thing, yeah. It's not something that we like. Are we allowed to ask for other witnesses? I mean, because if I want my own clients, I just ask them for it, you know?
We're talking about, I think, other people. Like we're trying to get it either from
Yeah,
other witnesses or parties or
you are
something.
able to get it. Yes.
How do you ensure the admissibility of witness testimony and electronic evidence during the trial proceedings? Well, the first and foremost thing is you as the attorney should not be collecting it. You want an ancillary person, a PI, an assistant, a paralegal, someone else grabbing it, because if that witness or that information disappears and is not available, then you have someone that's not you that can testify under most of the hearsay exceptions. You would try
Exactly.
to be able to get that in. So that's the number one thing. You want someone else collecting the data. And how are there any specific challenges or nuances we should anticipate when dealing with witness testimony and electronic discovery in
Authentication
this
is a big one.
particular case? I'm sorry?
In this particular case, in what particular case? Oh, in Crumbly?
I don't know what this particular case is.
I think she's talking about Crumbly.
We could just talk generally. Authentication, yeah, that's the
Yeah.
biggest one. Again, another reason why you want someone else to do the data dump. Be like, yes, this specific person showed up with this specific cell phone that they said was theirs, and then this is the data from it, right? So,
also, it can be like a little bit when you're talking about social media and that kind of stuff, it can get a little bit harder, but it's possible, and it's obviously a lot easier if they'll admit that that's their screen name or their Facebook page or whatever.
If we're talking about Crumblies, obviously, well, James isn't testifying right now. Jennifer testified, but afterwards, right? The state couldn't call her. So you need to establish the foundation and the authentication. And we talked about this a little bit the other day. When you're doing that, it's a pretrial issue. If you have authentication issues, usually most of that is worked out ahead of time with motions and things like that. Presumably, they turned over a Cellbrite report for all these different extractions that they did, and everyone agreed, yeah, that's my Facebook. Yeah, those are my text messages. This information is accurate. So we're not really challenging it. We're challenging whether or not it's relevant. We're challenging what it actually means, what the context around it is. But they're not really challenging it. So there is an opportunity to challenge the particular data, but that's all pretrial stuff. Once you're at the trial stage, it's done and over with.
It's coming in.
It's coming in, yeah.
You already know it's coming in.
Or at least it's been authenticated somehow.
Yeah, or unless it was something that was like in like motion in limine and the judge is like, oh, I'll rule on it at trial. Right?
Yeah, which
or
some
something
judges
they're just going to hold off ruling until trial.
Yeah. So, okay. I think that's all the questions. So hopefully we helped you with your law class, Lady Law Sandra, and hopefully most of you found it entertaining.
And hope you don't fail from our answers.
But MLS said.
That'd be terrible.
Let us know what your grade was. That would be great. All right. I'm going to send you guys over to Ghazni. Tell him I said hi. And I'm going to go relax for the rest of my evening. And tell him that Legally Live said hi too. So, all right. Legally Live. You got anything coming up? By the way, tomorrow I got Jody at noon Eastern. By the way, nice. Jody Arias. We're still streaming that. But McKinley,
tomorrow I do not have anything because my child has 3 birthday parties. But on Sunday, I think at 3:30 Central, so 4:30 Eastern, I think I'm going to do another. I'm not sure anybody in here cares about this, but another What the Hell's deep dive into their videos. But I actually have the timestamps and stuff, and I'm going to stick to it.
I'm going to watch those because I need to get caught up on that. I need to know the whole story. I met the guy today, and I don't even know his story. So
yeah.
Just know what the crazy
I'm not doing the court stuff because that's been that people have gone over that and gone over that and gone over that. But if you do want to get caught up like later at some point, I might have my dad watch them with me. You could definitely come on if you ever wanted to and watch those. But right now we're just doing their like videos to show corruption in Otter Creek.
Murphs, thank you very much for another 5 gifted memberships. I appreciate it. And if you guys had memberships before and you don't now, it's because I got rid of 2 of the 3 membership levels that I did have. So I will, you have to re-sign up for it or get it gifted to you by Murphs. So I appreciate it. And Wendy also gifted 10 memberships. So Wendy, you got to step it up because Murphs got 5 more than you now. But I will leave you all to Ghazni. You all have a wonderful day, and we'll see you tomorrow at noon for Jody.
When I was young, my dad